Good morning. This is Rich Sierra. I'm the president of Florida Small Business Legal Center. I'm the host of the Business SOS podcast. Thank you for listening today. This is the first show of 2024. So first, I'd like to wish everyone a happy new year, a prosperous 2024, and great things happening to you, to your family, and your business. So today, it's going to be in my series as I talk about Business SOS, which is, kind of a spin-off of my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. It's available on Amazon, Barnes & Noble, and you can ask for it at your local bookstores. I talk about mistakes that business owners make through our legal mistakes that they make that eventually will cost them money. So today I want to talk about, it's a spinoff of a TV show that I love. The show is Help, I Wrecked My House with Jasmine Roth. It's an HGTV, and basically today's topic is going to be Help, I Wrecked My Case. So I'm going to talk about 5 different ways you can wreck your case and how to avoid them. And the reason it's a spinoff of that show is basically, or I'm basically hope I don't get sued, but basically what I'm going to do is, what I like about the show is that they're homeowners that try to do it themselves. They try to go in and do some home improvement projects in their house. Maybe they go to YouTube and they find ways to say, I can do this. I can remodel my bathroom, go to Home Depot, pick up some parts, and I can just follow the instructions. They have no background in construction. They're not plumbers, not general contractors, but they give it a shot. And the couples with great intentions, they try to do it, kind of a weekend project because they have jobs and just basically, and the videos are very compelling when they submit their videos to Jasmine to help them, because you see the progression of the compounding problems that they create for their house. And at the end of the day, they say, we cannot do this and we need help. And she comes in with a great deal of compassion and looks at the problem and find out and helps them how to resolve it. And then she comes in with her team of designers and really transforms the house, but also really saves that couple or that individual who has that problem that wrecked his or her house, and really comes in and really creates a transformation and gets them out of that problem. And the lesson of the show is basically you got to hire professionals when the work that you need requires professional assistance. So, and the analogy also is basically with law. We're trained professionals, we're licensed, and we are experts in our field. And there's some legal issues that come up in your career, in your business life, that requires an attorney to help you with those. One of them is a lawsuit. And I'd had a couple of episodes back, I went into a deep dive into litigation, but we are familiar with what a lawsuit looks like. Either you're suing someone for either a breach of contract case or money damages or negligence, or they're suing you. So in essence, you have a complaint, which is the pleading that tells you what the allegations are. And it is not like going to a TV show that you go from a pleading, go to a trial in 30 minutes. It does not work that way. In fact, in my experience doing business litigation now for 19 years, and this will be my 20th year in October doing this, 80% of litigation is procedure. You don't see, you as the client are not going to be involved in the case that much, with the exception of your deposition being taken, maybe an evidentiary hearing, a mediation, or if you have to, the case goes to the way to trial, then you go to trial at the end of the case. That's maybe could take about 12 to 18 months. So for the most part, it's procedures that the attorneys are involved with in discovery. So it can be very costly. It is very costly. It's very time consuming. It's very stressful. So when, if you try to do that yourself, it's going to be a nightmare. I'm just going to be honest with you. It's going to be very, very difficult for you to go do that. So 5 ways, I want to talk to you 5 ways you can wreck your case. And that means that you probably could win the case. You probably can come out of it in not a bad position, but you can make some unforced errors thinking I can handle this myself and make it worse for yourself by taking certain actions. And I'm going to tell you about those. So that way, if you're in a situation that either you are suing someone or you're on the receiving end of one, not to commit these mistakes and perhaps get the professional assistance, get an attorney to help you navigate this, the waters of litigation, which are very treacherous in my opinion. So one of the mistakes that I see some clients I've done in the past is that it's basically representing yourself in a lawsuit. If you are the recipient of a lawsuit, you receive a summons and you receive a complaint, and especially if the complaint is signed by an attorney, not by another individual, my advice at that point is basically do not handle the lawsuit yourself. At that point, take a deep breath. For the most part in Florida, you have 20 days to respond to the lawsuit. So the initial reaction when you receive a lawsuit is you're angry, you're upset, how could this happen? You want to have a knee-jerk reaction to react, to go ahead and say, I want to go ahead and I want to respond to this very quickly. The allegation that what they're saying here is there are lies. These are not true. And the fact is, if you're being sued for something, they're not going to be flattering comments in that lawsuit. I can tell you do not take it personal, but that's going to be difficult for me to tell you that because you will take it personal, and that's fair. There are allegations that are made there, and sometimes attorneys write inflammatory statements that based on what the client have told them, and they write it and it basically makes it into a lawsuit, and you're legitimately upset. There's no way around it that you will be upset about what is written there, that complaint. But how you react to it and what you do is up to you. So use the time effectively. Don't go ahead and start saying, I'm going to do this myself and call the lawyer and start arguing with the lawyer, why you're suing me. I mean, this is to happen. Or call the opposing party and start yelling and screaming and start getting into some type of shouting match. It is not worth it. Once you receive a lawsuit, my advice, take a deep breath, okay? You can put it aside for a few hours if you want, and then, but at that point, my recommendation is begin to look for an attorney. Depending on the type of lawsuit that you receive, whether it's a negligence suit, whether it's a business lawsuit, find the attorney that is more appropriate for the type of lawsuit that you receive. You can call a colleague for a recommendation. You can go on the web, but find an attorney to use the time effectively. You have 20 days. So that in day one, begin to start interviewing attorneys that can help you with your matter. Whatever you talk to that attorney, whether or not you retain that attorney for your services, it's attorney-client communication. So that attorney cannot share that with anyone. So, and many attorneys offer free consultations. So that's your homework. At that point, that is your homework, is to begin to look for an attorney, but do not respond to that lawsuit. Use the time effectively. So that mistake number one, representing yourself in a lawsuit, is key, simply because if you decide to represent yourself in a lawsuit, it is assumed that you know the rules of court. With the exception of small claims that you can represent yourself, and that one, depending on the type of case that it is, you may or may not need attorneys, but I'm not talking about those types of claims. The small claims matter, you can represent yourself. You're not required to have an attorney. If you want to, you can, but it's not, the amount of controversy is not, usually people represent themselves for the amount of the dispute. You're going to be outmatched. If you go against an attorney who's a business litigator, or commercial litigator, or civil litigator, even if you have the best case in the world, I'm almost certain you will lose the case. So don't go into a match with an attorney, into a business dispute or a litigation matter against an attorney who knows what he or she's doing, you will lose. Okay, so get a lawyer. Don't represent yourself. Another mistake number 2, which is kind of it goes along with mistake number 1. Represent yourself in a lawsuit. This one is writing a letter to the judge with explanation about the case and sometimes attachments. And I'm smiling because it's just, people, when they come to me and they said, yeah, I got ahead and wrote a letter to the judge, and I'm like, why? Why do you do that? You get a lawsuit, get a lawyer, but at the moment that you write a letter to the judge, it is considered an answer. And a lot of times you might be making admissions in that answer that you don't have to make admissions to. And it is done as a knee-jerk reaction. It is done sometimes because, well, I cannot afford a lawyer. I got to do this myself. There are plenty of lawyers available at different types of budgets and at different types of hourly rates. And some of them offer flat fees as well, depending on the type of matter that you have. But if you're going to do that, that should be the very, very last resort. But I'm certain that if you make some phone calls, you most likely will find an attorney who can get you to a certain place so you avoid these mistakes. But do not write a letter to the judge. The judge's not going to read it. The reality is judges have, at least in Florida, maybe 3,000 cases each or more. So when you write a letter to the court, the clerk of the court receives the letter and it goes into the docket, which can be accessible to the public records. The only time a judge reviews any type of correspondence from a party or from a party to the lawsuit is when there's a hearing that the judge will have to review the documents before the actual hearing. It could be a motion to dismiss, a motion for summary judgment, a discovery dispute. So by writing a letter to the court, all you're doing is basically answering, and you might have waived many defenses that could have been available to you at the time if you did not send that letter in the first place. There are ways to correct it. And what happens is that when you write the letter, and I'm going to make a caveat here. If you're in a business, if you have a business entity, anything above county court, anything above small claims, you must have an attorney representing the business entity. Otherwise, if you write something on behalf of the entity, it could be stricken and you can lose the case. So that's Florida law. You must have an attorney to represent you in a lawsuit if you're a business entity, anything above small claims. Corporate officers can represent the entity in small claims. Okay, so I just want to make you understand that. When I say anything above small claims, anything above $8,000. If it doesn't say small claims, you pretty much need an attorney to represent your business in a lawsuit. Okay, so do not write a letter to the judge. Do not make any attachments. Do not start attaching screenshots, text messages, emails. Don't do that. Go back to advice number 1, get a lawyer. Don't represent yourself in a lawsuit. Do not write a letter to the judge with explanation about the case. Okay. Mistake number 3, missing court deadlines. Okay, these are enforced errors. The court system, they all have different deadlines, and now Florida kind of followed the federal system that they automatically create a calendar for the case. The objective is to, from the time a case gets filed to the time the case gets adjudicated, whether it's a trial or a bench trial, which is with a judge, or a jury trial, you want to complete in between 18 months from the time of filing. So now what the courts are doing, they have what is called a case management schedule that sets some specific deadlines that the parties must comply with, and that is served with the initial pleadings. So if there are deadlines to serve, which is 4 months, you cannot miss those deadlines. And but let me talk what really affects you the most is when you miss a deadline to, for example, respond to the lawsuit. You have 20 days to respond to the lawsuit, okay, if you get sued. If you have not found an attorney by the 19th day, okay, and if you basically cannot find an attorney, you want an extension to that to respond, the only time that I would advise you to write a letter to the court is that you want an extension of time to find an attorney. Simply that. Not an admission, is that you want an extension of time. You can also call the attorney or email attorney and say, can I have an extra 10 days because I'm interviewing attorneys? By filing that single piece of paper with the clerk of the court, that automatically avoids what is called a clerk's default. That's the only time that I will say you can write a letter simply to ask for an extension if you have not found an attorney at that time. Many attorneys, as a courtesy, will give you that. If you say, I just need an extra 10 days, can I have 10 days to respond? And then you get that confirmation with the attorney and via email, that's sufficient. It'll be bad faith if he decides to default you after you give you 10 days. But if you want to be certain, you can, that particular letter you send to the clerk of the courts, say, I want an additional 10 days. Filing that piece of paper in and of itself is sufficient to stop a clerk's default. And then you send a letter to the attorney, like the attorney is going to agree to it, and you have the extension. Again, that's the only time that I will say write a letter, because that way you do not miss the deadline, the 20-day deadline. You're not answering the lawsuit. You're simply asking for an extension. Okay. With deadlines also, discovery deadlines, and that goes into mistake number 4, but it's still in mistake number 3, which is missing court deadlines. At times, if part of the case, you're going to be required to answer some discovery. Very likely. Not required, but if it's discovery, meaning that they're going to be, the other opposing side will send you what is called interrogatories. Interrogatories are questions that you will be required to answer under oath. Usually you're given 30 days to answer those questions. The attorney will need them before that to review them, but the deadline is 30 days for interrogatories. The same thing for production of documents, that it is submitted to you for you to produce documents regarding the case. There can be a lot of volume of documents. The request can be burdensome. They are burdensome. They're very detailed. And that's something, when you receive a request for production of documents, it's not a good idea to wait to the 30th day, 29th day, say, what documents do I need? So missing and announced requests for admissions that they make you to admit or deny allegations regarding the lawsuit, and they really want you to admit them for the purposes of trying to get this into a summary judgment or try to short circuit the case through a judgment by the judge. Now, I know I'm talking about some technical issues here, but the point is you have to meet those deadlines. So if your attorney tells you, okay, we had the discovery sent to us and we have 30 days, try to get them done in 15 days. So the attorney has 2 weeks to review them and get back to you and tell you, okay, I'm missing the following documents. I need the following questions answered. I need these admissions clarified. So that way you're not dealing with a crunch in time to answer those discoveries. So a mistake that I see people do is that they get the discovery request that said we need the discovery by the 15th of the 30-day period, and they just don't do anything. I never got back to it. I was busy. I was traveling. Fine. Okay, so you say, give it to me by the 20th day. Still don't do it. So the 30th day comes in. Then what happens is we have to basically ask for an extension of time to respond to it. And attorneys on the other side, in good faith, sometimes grant like a 10-day, 15-day extension if there's nothing pending on the calendar. But that puts you in a position that now you are asking for a favor from the other side. You cannot go in an offensive position because you're asking them to give you a concession on something you should have done in the first place, which is comply with the discovery. So if you're given discovery request, just understand this is your case. The attorney's there to help you, but the answer to the discovery, to the interrogatories, comes from you. The the documents for a production request comes from you. The admissions come from you. We can only evaluate those and make an assessment how that will affect your case. But you got to help us help you. So a mistake that I see is that people do not take discovery requests seriously, and then it becomes an issue that it puts your attorney at a disadvantage, at a tactical disadvantage, because then the attorney is scrambling to ask for extensions. It's had to basically, something that could have been done in advance now has to be pushed to the last minute. When you do things in the last minute rushed, it's not the work product that's going to come out. It's not going to be as good as the work product coming out when you planned it in advance. And then you might have to do amendments. And so a mistake that I see is that I want you to share with you. Number 3, do not miss court deadlines. They're important. Yes, you can have a slight extension if you request it for the right reasons, but missing court deadlines, then it becomes an issue. And if you do that multiple times, it can end up costing your case. And again, this is an enforced error that I see many people doing. On the same topic of discovery, this will be mistake number 4. And it's not responding properly to discovery. And this is very important. So you're given interrogatories about your case, and we propound interrogatories. We serve interrogatories to the other side as well. Whether we're plaintiff or defendant, we do the same thing. The discoveries is for 2 purposes. Number 1, the interrogatories want to get questions, factual questions about the case in preparation for a deposition or in preparation for motions that we're going to do later on in the case, in preparation for trial. So it's important to take the time to read the questions, understand the questions, and answer them truthfully and to the best of your knowledge and belief. And the final response goes through various drafts. It's not the first time that you write it, it's going to go through. The attorney's going to review those questions to make sure they're thorough, they're truthful, and if there's an impact on the case, they'll discuss that with you. But the objective is to take them seriously, answer them to the best of your ability, and basically provide the discovery, the answers. The way I do mine is basically I send that out. Our paralegal, Richard Ferriello, goes through the first draft of them, get on the phone with the client, and basically let's go ahead and go through these questions. Questions that the client may not understand, so set them aside. That's fine. And then I'll go over those questions with the client and basically see if we can clarify some points to make sure that the client understands the question and the client is able to answer the question properly. Then we'll do a second draft with everything in there. Then we'll have you, the client, review it. If it's exactly the way you want it, if the questions are a true representation of your answers, then we'll get it finalized and we'll serve it. The same thing with production request, document production. They might ask you, for copies of contracts, copies of text messages, copies of email communication between you and the other party. This is the standard questions that they're asked. So I'll do the same thing. Go through a list of questions. Some of them might be repetitive. That's fine. They do it to make sure that they did not miss anything. So documents that you already have, you check those off. I have these documents, copies of contracts, yes. Bank statements, yes, I have those. Documents that you do not have, no idea what they are, you say, no, I don't have these. Cross them out. Documents that you might have a question on, you're not really sure, we'll set those questions aside, those requests aside, and look at them later, and then find out whether we can get them, we have them, do they exist. We go through that process. So my point is that responding to discovery is a process. It's not something that just automatically happens. But not responding properly to discovery, then they can file motions to compel. Then the judge can compel you to answer discovery. It's just become then, it's a distraction from the facts of the case. Last but not least is number 5. Not cooperating. This is a two-part. Not cooperating with your attorney and withholding information about the case with your attorney. So it's kind of like really 6, but we'll put in number 5. So cooperation, what I mean. Okay, if your attorney asks you, listen, you talk to you 50 minutes, you usually have a paralegal, a secretary, or assistant, text you or email you. The attorney wants to talk to you 15 minutes. Make yourself available. So that way, it might be an issue of clarification or question, but not make yourself available for the attorney. And then it becomes an issue that the attorney might not be able to assist you when the attorney needs some information from you. Also, withholding information about the case with the attorney, that includes whether there are facts about the case, whether there's documents about the case, and something that you may think may not be important about the case. It's important to share the good, the bad, and the ugly with your attorney. I'll tell you why. The other side is doing a lot of investigation on you. The last thing you want is that for your attorney to find something in a deposition about the case that you did not share with the attorney, and it's damaging to your case. So whatever information you have about your case, even if you feel might not be in your benefit, share it with the attorney. It's confidential and privileged, and the attorney will decide how to handle that piece of information. But the last thing you want is for your attorney to learn for the first time something that is not good for your case on a sworn deposition testimony that is taken to you by opposing counsel. It's not good. So share it, tell the information, because by not sharing the information, it can devastate your case. It can basically wreck your case, which is the theme of today's podcast. So just to recap, the 5 ways you can wreck your case: representing yourself in a lawsuit, writing a letter to the judge with explanation about the case, missing court deadlines, not responding properly to discovery, not cooperating and withholding information about the case with your attorney. Now, this is not a checklist. I want you to do all of these at once, please. That would be a really bad day. But by any chance you're in a situation that you did one of these, don't despair. Okay, call an attorney that might be able to. All these mistakes can be fixed and should be fixed. Okay, so it's not all lost. So you're in a situation that you started working in this case by yourself, tells you made a mistake, that's fine. The attorney can come in and try to help you fix it. It might take a little bit more work, but you're better off at least getting the assistance at some point versus no assistance. So I'm just sharing this with you, not to judge you. It's basically to share with you, listen, you're in this situation. We're not going to judge you. Don't worry. It happens. Okay. We're business owners. We are driven. We're problem solvers. And sometimes we do things that we shouldn't do. And that's fine. No big deal. Okay. So the lesson today is that you're in a lawsuit, call an attorney. So I'd like you to participate in the show. If you have any questions about any topics you'd like me to cover, please send me an email at rich@richsierra.com. If I select your question and I, go over in one of my podcasts, I'll send you a free autographed copy of my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. If you want to learn more about our legal services, our website is FloridaSmallBusinessLegalCenter.com. We're on Facebook at FSB Legal. If you are watching this video, if you want to see the video of the podcast, we're at youtube.com/@RichardSierra. We're on Instagram at FSB Legal. You can call us at 866-842-5202. Remember to follow the show. Give us a 5-star review. I certainly appreciate that as well. And subscribe to our YouTube channel. We upload these podcasts every week, and I hope that you enjoy the podcast and information as well. I want to wish everyone Happy New Year. It's going to be an exciting 2024. This is Rich Sierra. Remember that my goal is to help you succeed.